Imagine this for a second. You want to start a business, and you want to do everything right, strictly by the book.
The responsible approach.
Totally. So before you even get going, you write a letter to the government, to the highest tax authority in the land, and you ask a very simple question. Based on how my business works, am I supposed to pay this tax?
That's just smart. You're asking for permission, not begging for forgiveness later.
Exactly. And they write back on official letterhead. And they say, no, you're exempt. You don't owe this tax. Go forth and prosper.
Okay, that's the golden ticket. You have it in writing. That's something you can take to the bank.
Though you do. You operate for a decade. Your pricing, your contracts, your whole financial structure is based on that letter. Then 10 years later, you get a bill. A bill for hundreds of millions of pesos. And the government basically says, oops, we changed our mind. You actually did owe us that money for the last couple of years, so
yeah,
pay up.
That is a true bureaucratic nightmare. It's the kind of thing that gives CFOs heart attacks. And it's exactly what happened in the case we're diving into today.
Welcome back to the deep dive. Today, we are unpacking a real legal thriller of a tax case. Commissioner of Internal Revenue versus Philippine Healthcare Providers, Inc., or GRNM 168129.
This is a fascinating one because it's about so much more than just taxes. On the surface, sure, it's a dispute over numbers, but deep down, it's a showdown about whether you can trust the government's word.
And the stakes were just astronomical. We're talking about a demand for over 224 million pesos.
Right, an amount that could easily bankrupt a company. And the legal fight really gives us a masterclass in two things. First, what a business is versus what it says it is. And second, this idea of equity and fair play in the legal system.
So that's our mission today. We have to solve an identity crisis. Is a health maintenance organization an HMO, a medical provider, or is it just a middleman?
And then the big one. If the government makes a mistake in a ruling, can they punish the taxpayer for that mistake years down the line?
All right, let's get into it. The main players are the Commissioner of Internal Revenue and Philippine Healthcare Providers, Inc. We'll just call them the healthcare company to keep it simple.
And they were operating what they called a prepaid group practice. Now, for you listening, just think about how your own HMO works.
Yeah, you pay your annual fee, you get a card, and when you get sick, you go to a doctor in their network. You show the card, and you don't pay cash.
Exactly. It feels like a medical service.
To me, it does. I pay for health. If I get sick, I use the card to get fixed. The card is the health care, as far as I'm concerned.
And that perception is really the core of the whole argument, especially around the value-added tax, or VAT.
Okay, so let's get into the weeds here. Under the tax code, Section 103 says that medical, dental, hospital, and veterinary services are exempt from VAT.
Which makes perfect sense, right? You don't want to tax people for being sick. It makes healthcare more expensive, which is just bad public policy.
Right, so the healthcare company's argument was pretty straightforward. Look at us. Our members pay us, they get medical care, therefore we provide medical services. We're exempt.
On its face, that seems completely logical.
It does. But the Bureau of Internal Revenue, the BIR, eventually took a much closer look at the mechanics of the business. They looked under the hood.
And this is where we get to our first major concept, the conduit theory.
The conduit theory sounds like something to do with plumbing.
In a way, it is. It's about how the service flows. The Court of Tax Appeals, and later the Supreme Court, had to ask, does this company actually perform the medical service? Do their employees hold the stethoscope?
Well, their network of doctors does. They accredit hospitals. Doesn't that count?
But that's the key distinction the court found. The healthcare company doesn't usually employ the doctors. It doesn't own the hospitals.
I see.
Instead, they contract with independent physicians. They accredit third-party hospitals. The doctor doesn't work for the HMO. The doctor has a deal with the HMO.
So they're not providing the service, they're arranging it.
Precisely. They are the bridge. They handle the financing, the administration, the paperwork. They connect the patient to the doctor. They are a matchmaker, a middleman, a conduit.
And that makes them what, legally?
A service contractor. And this is where the law flips. The exemption in Section 103 for medical services goes out the window, and Section 102 comes into play.
And what does Section 102 say?
It says service contractors are very much subject to VAT. At the time, it was 10% of their gross receipts.
So that's the identity crisis solved. They thought they were one thing, a medical provider, but the law saw their operations and said, nope, you're a service contractor.
That's the technical truth. Being in the business of health is not the same as practicing medicine in the eyes of tax law.
It's like the difference between your auto mechanic and your car insurance company. The insurance company pays the bill, but they don't fix the car.
A perfect analogy. The HMO is the insurer, not the mechanic, and facilitators get taxed.
Okay, so if the court decided they should have been paying VAT all along, that sounds like game over. They owe the $224 million.
You'd think so, wouldn't you? If we stopped right here, that would be the lesson.
But there's a twist.
There is a huge twist, and it all comes down to the timeline.
Right, because they weren't just randomly deciding not to pay taxes. They had a reason.
A very good reason. We have to go back to 1987. This is before the big VAT law even took effect. The healthcare company writes to the Commissioner of Internal Revenue, the CIR, and asks for a ruling.
Hey, this new law is coming. Where do we stand?
Pretty much. And in June 1988, they get their answer. It's called VAT Ruling Number 23188.
And the ruling said?
It said, explicitly, that as a provider of medical services, they were exempt from VAT. The government itself told them, you're covered by Section 103. You're good.
That's the written yes, the golden ticket we talked about.
It gets even better. In 1994, a regional director confirmed this exemption again. So for over a decade, they're operating with total confidence based on written assurances from the government.
They would have set their prices, their premiums, based on not having to pay that 10% tax.
Of course. VAT is an indirect tax. You pass it on to the customer. If the government tells you you're exempt, you don't collect it. So if they come back 10 years later and ask for it,
you have to pay it out of your own pocket. You can't go back in time and bill your clients from 1996.
Exactly. And that's what happened. In January 2000, the demand letter arrives. Pay up for 1996 and 1997.
The betrayal.
The government's argument was basically, we were wrong back in 1988. We've reanalyzed the law. You are a service contractor, so here's your bill.
I mean, from a simple fairness perspective, that feels so wrong. It's like being told a road has no speed limit, and then 10 years later getting a ticket for every time you drove on it.
And that gut feeling you have that, hey, that's not fair reaction, that is precisely the legal principle the Supreme Court had to tackle. This brings us to the safety net.
Section 246 of the tax code. This feels like a really important one for people to understand.
It is a shield for the taxpayer. It's called non-retroactivity of rulings. And it says that any reversal of a BIR ruling cannot be applied retroactively if it's going to prejudice the taxpayer.
So in plain English, if the BIR changes its mind, the new rule only applies from today forward, not backward.
In general, yes. If you relied on their old ruling in good faith, they can't punish you for it. It would create total chaos in the business world if they could.
But I'm guessing there are exceptions. There have to be trapdoors.
Oh, absolutely. The government can apply a reversal retroactively in 3 specific situations.
Okay, what are they?
1, if the taxpayer deliberately misstated or omitted material facts in their application. Basically, if you lied.
Makes sense.
2, if the facts on the ground are materially different from what you presented. So you said you were running a bakery, but you were actually running a casino.
Got it. And the third?
If the taxpayer acted in bad faith.
And that was the core of the fight, right?
Mm-hmm.
The BIR was essentially arguing that the healthcare company acted in bad faith, that they tricked them back in 1988.
That was their argument. They said, you told us you were a medical provider, but you're really a middleman. You misrepresented yourselves.
But did they?
Well, the court looked at the original 1987 letter. The company described itself as a prepaid group practice healthcare delivery system.
Which is a bit of a mouthful.
It is, but the court found it was accurate for the time. They explained their whole model contracting with doctors, accrediting hospitals. They laid out the mechanics of being a conduit right there in the letters.
Okay, they didn't hide anything. The BIR just misinterpreted their own rules back then.
That's what the court found. The government made the mistake based on accurate information. And here's the most fascinating detail, my favorite part of this whole case.
Go on.
The term Health Maintenance Organization, HMO, it didn't even exist in Philippine law until 1995.
Wait, really? So they couldn't have called themselves an HMO in 1988 because the word wasn't a legal term yet?
Exactly. The National Health Insurance Act of 1995 was the first law to define it. So when the company asked for the ruling, they used the best description they had. The legal label for what they were just hadn't been invented yet.
That demolishes the bad faith argument. You can't be accused of hiding your identity if the name for that identity doesn't exist.
Precisely. The court said you can't equate that with bad faith, and since they acted in good faith,
Section 246 applies. The shield is up. The reversal of the exemption is valid, but only moving forward. It can't go back to 96 and 97.
And this all boils down to that core principle of equity and fair play.
I love that that's actual legal language. It sounds like something from a sports manual, not a court decision.
But it's fundamental. The court said the commissioner is precluded or stopped from taking a position that's contrary to a previous one if doing so causes an injustice. It's about reliability.
And accountability on the government's part.
It is. The court defined good faith as an honest intention to abstain from taking any unconscientious advantage of another.
That's powerful. It's a moral standard. It means the government has to recognize that people build their lives and businesses on its assurances.
If the BIR tells you you're safe, you should be able to rely on that. If they realize 10 years later they made a mistake interpreting the law, that's their mistake to fix for the future, not the taxpayer's mistake to pay for in the past.
So in the end, what happened to the 224 million peso bill?
The Supreme Court canceled it. The healthcare company did not have to pay the deficiency taxes for those years.
A massive win for them.
A huge financial win, yes. But it's important to remember they also kind of lost the main argument. The court was clear. Moving forward, HMOs are service contractors. They are subject to VAT.
So the 1988 ruling is officially dead. The shield works for the past, but it's gone for the future.
Exactly. They have to pay their taxes now, but they didn't have to pay for the government's decade-old error.
So for our listeners who probably aren't running an HMO, what's the big takeaway here?
First, paper trails are everything. If you're operating in a legally gray area, maybe in a new tech field or the gig economy, get a ruling from the tax authorities. Get it in writing.
Don't just guess.
Never just guess. That piece of paper from 1988 was worth over 200 million pesos. And second, understand what your business actually does, not just what industry you're in. Are you the service provider? Or are you the facilitator, the conduit?
Because the taxman will look at the mechanics, not the title on your business card.
Precisely.
Okay, before we wrap up, I want to leave everyone with a final thought. The court leaned heavily on good faith, and they defined bad faith as knowing something that ought to put the holder upon inquiry. Basically a situation where you should have known better.
Right. The old ignorance of the law is no excuse.
But tax laws change all the time. The law that defined HMO was passed in 1995. The demand letter was for 1996 and 1997. At what point does, I'm just following my old ruling, stop being good faith defense?
That's the million-dollar question, isn't it?
How much responsibility does a taxpayer have to constantly check if the government has changed its mind before the bill shows up? In the internet age, where new regulations are published instantly, can anyone really claim they didn't know the landscape had shifted?
It's a fine line. Good faith is a shield, but it can't be an excuse for willful blindness. You have to stay informed.
Something to think about. That's it for this deep dive into the middleman, the mistake, and the rules of fair play.
Thanks for listening.
Goodbye, everyone.